Hi everyone. So today's session that we're doing is contract law unit, and the learning outcome we're doing today is learning outcome 2, which is to understand the key elements of a binding contract. My name is Shazia Khan. What I'm going to do before I carry on with learning outcome 2 is I'm going to go through a summary of what we did in learning outcome 1, which was in the last session. So learning outcome 1, we looked at knowing the key principles of contract law. So we looked at identifying 1.1, which was to outline the key principles of contract law. So we looked at what a contract is, which is an agreement between two or more parties, a legally binding agreement. And it's an example of that is, for example, if you go into a restaurant, you go sit down and you purchase some food, and that is a contract once you pay for that. So we looked at the rights and obligations of a contractual party within a contract. We also looked at, in learning outcome 1, is how a contract is made. So how it begins with an offer, which is in exchange, like I said, for the service. So in the restaurant, the service, exchange for acceptance, and then a formal agreement. We then went on to look at what is a legally binding contract. So it requires 3 elements. A valid contract requires the presence of 3 elements: agreement, an interaction between the parties to create any sort of legal relations, which is a legally binding relationship, and then consideration, which is in the form of payment. We looked at certainty of terms, where an enforceable contract requires any sort of certainty to its term. So it must be clearly implemented, and there must be terms in regards to it. We looked at the basic principles in contract law, which are offer, acceptance, consideration, contractual intention, and form. Then the contents of a contract, which are things like express terms, implied terms, and then we looked at the basic principles, which is when this contract comes to an end, expiration, termination, vitiation, and frustration, damages, and remedies. So we looked at 1.2, which was to describe the different classification of contracts. Here we looked at the type of contracts. So it could be on the basis of formation, on the basis of nature of consideration, on the basis of execution, and on the basis of validity. We then went on to look at contracts on the basis of formation, which was, we looked at express contracts, where the parties actually state the terms, either orally or in writing, at the time of its formation. We looked at implied contracts, and that consists of obligations arising from a mutual intent and an intent to promise. We then went on to look at quasi-contracts, and where there's no offer and acceptance, so actually there's no contractual relations between the parties. We then looked at contracts on the basis of consideration, so we looked at bilateral contracts, where the consideration, if the considerations in both directions are moved after the contract, and then a unilateral contract, which involves a promise that is made by only one party. We then went on to look at contracts on the basis of execution. So we looked at an executed contract, an executory contract as well in regards to execution. We then looked at contracts on the basis of validity. So we looked at a valid contract, which is enforceable in a court of law, and then we looked at a void contract, if a contract is deficient in any one or more of the above features, and then we looked at illegal contracts as well. We looked at voidable contracts, how they are legally enforceable agreement, but can be treated as never having been a binding on a party. We looked at unenforceable contracts as well, where a contract which has not properly fulfilled its legal formalities, and unenforceable contract suffers from technical defects and insufficient stamps. We looked at, this is all in learning outcome 1, we looked at illegal and voidable contracts. If a contract is illegal, it cannot be enforced by a court or tribunal. and then it exists as a legal purpose, and a void will not be enforced by the courts. So that was in regards to looking at the formation of a contract and the key principles of a contract in learning outcome 1, sorry. And now we're going to go on to learning outcome 2, which is today's session, which is to understand the key elements of a binding contract. So firstly, we're going to look at the learning outcome, which is to distinguish between an offer and an ITT, which is an invitation to treat, explain the issues regarding the postal rule, and explain consideration, which is the rules of consideration and the test for enforceability. So 2.1, distinguish between an offer and an invitation to treat. So what is an offer and acceptance? So an offer is a statement of the terms which the client is prepared to contractually bound. So in contract law, it's an expression literally of willingness to contract on a specific set of terms. An offer may be expressly or orally or in written form or by conduct. And it can be addressed to a single person or to a specified group of persons or to the world at large. The offer must be complete, specific, and capable of being accepted. It must include the fundamental terms of agreement with the intention that no further negotiations are to take place. If client offers contractor the work, and therefore the contractor must carry out that work under the client's terms and conditions. It's possible to make a conditional offer. The effect of this is that an offer cannot be accepted if the condition has not been satisfied. For example, if the client requires a contractor to have a specific tool or machine before an offer can be made. An offer is essentially a proposal made with the intention that if accepted by the person to whom it is addressed, which is the offeree, the person making the offer intends to contractually bound by it. Whether the offer is made with the requisite intention to is assessed objectively. Accordingly, the offerer will be bound if his words or conduct are such as to induce a reasonable person to believe that he intends to be bound, even in the fact he has no intention. So termination of an offer. An offer may be terminated or revoked if the offer is withdrawn or revoked at any time prior to acceptance, provided there has been communication between the client and the contractor. The client making the offer dies, or failure of a condition, or reasonable period of time has lapsed. A time limit is specific on the offer. The general rule here is that an offer can be withdrawn at any time, as we've just mentioned, them elements. To be effective in law, the offeree must be informed that the offer no longer stands, although such condition need not come from the offerer, but rather be made by a third party. An offer may also come to an end, as we mentioned, through lapse of time or the occurrence of a condition. With lapse of time cases where there's no time frame is specified by acceptance of an offer, the offer will remain open for a reasonable period of time. What constitutes a reasonable period depends on all the circumstances. If, on the other hand, the offer stipulates a time limit within which acceptance must occur, the offer must cease to be open for acceptance once that limit has expired. And a really important case in regards to this, where an offer expressly provides that it is to determine the happening of a prescribed condition, was the case of Harvey and Facey, 1893, where Harvey sent a telegram to Facey which stated, "Will you sell us Bumper Hall pen?" And the telegraph lowest cash price answer paid. Facey replied by telegram, "Lowest price for Bumper Hall pen is £900. Then Harvey then replied, "We agree to buy Bumper Hall pen for the sum of £900. asked by you, please send us the title deed in order that we may get early possession. And it was held in this case that Privy Council held that there was no contract concluded between the parties. Facey had not directly answered the first question as to whether they would sell at the lowest price, stated was merely responding to a request for information, not an offer. There was thus no evidence of intention that the telegram sent by Facey was to be an offer. Another really famous case in regards to this was the case of Carlisle and Carbolic Smoke Ball Company, 1893, where a newspaper advert placed by the defendant stated £100 reward will be paid by the Carbolic Smoke Ball Company to any person who contracts the influenza after having used the ball 3 times for 2 weeks according to the printed directions supplied with each ball. £1,000 is deposited with the Alliance Bank, showing out sincerity in the matter. Mrs. Carlisle purchased some smoke balls and used them according to the directions and caught flu. She sought to claim the £100 reward. The defendant raised the following argument to demonstrate that advertisement was a mere invitation to treat rather than an offer. Firstly, that the advert was a sales puff and lacked intent to be an offer. Secondly, that it is not possible to make an offer to the world. Thirdly, there was no notification of acceptance. And fourthly, the wording was too vague to constitute an offer since there was no stated time limit as to catching the flu. And fifthly, there was no consideration provided since the offer did not specify the user of the balls must have purchased them. The Court of Appeal held that Mrs. Carlisle was entitled to the reward as the advert constituted an offer of a unilateral contract which she accepted by performing the conditions stated in the offer. In regards to acceptance, a fully binding contract is only formed if an offer is accepted. Acceptance is a final and unqualified acceptance of all of the terms of the offer. The offer must be accepted without introducing any new terms. Acceptance does not take place until communicated to the client making the offer. Communication of acceptance is the moment when the contract is formed and the acceptance must be the form of designated client. A contract will only be capable, as we mentioned, of being enforced if an offer has been accepted and an agreement reached between the parties. In contract law, acceptance is an unqualified expression of agreement to all of the terms set out in the offer. The term of an offer, as we mentioned just a bit in regards to acceptance, is made and accepted must also correspond. Accordingly, if a response to an offer seeks to vary a term or introduce a new term, it will not constitute an acceptance, but rather a counter offer. A counter offer has effect of extinguishing the original offer which the original offerer can either accept or reject. And the important case in regards to acceptance is the case of Entorozzi against Miles Far East, 1955. And it was a Court of Appeal case. And in this case, the claimant sent a telex message from England offering to purchase 100 tons of Corthodors from the defendant in Holland. The defendant sent back a telex from Holland to London office accepting the offer. The question for the court was at what point the contract came into existence. If the acceptance was effective from the time the telex was sent to the contract was made in Holland and Dutch law would apply. If the acceptance took place when the telex was received in London, then the contract would be governed by English law. And it was held that in this case, to amount to an effective acceptance, the acceptance needed to be communicated to the offeree. Therefore, the contract was made in England. Another really important case in regards to acceptance is the case of Brogden against Metropolitan Railway, 1877. In this, the claimants were the suppliers of coal to the defendant railway company. They had been dealing for some years on an informal basis with no written contract. The parties agreed that it would be wise to have a formal contract written. The defendant drew up a draft contract and sent it to the claimant. The claimant made some minor amendments and filled in some blanks and sent it back to the defendant. The defendant then simply filed the document and never communicated the acceptance to the contract. Throughout this period, the claimants continued to supply the coal. Subsequently, a dispute arose and it was questioned whether, in fact, the written agreement was valid. It was held that the written contract was valid despite no communication of acceptance. The acceptance took place by performing the contract without any objection as to the terms. Now we're going to go on to what invitation to treat is. So an invitation to treat is different to an offer as it only invites the party to make an offer and is not intended to be binding. The contractors are invited to bid on the job by calculating the total work total work cost and to have the tender submitted a specified time. The main difference between this situation and an auction is that person submitted the tender does in ignorance of others' bids because the final decision is up to the client. Invitation to treat can be anything displayed to a large number of people, as long as there's no defined way to choose who can accept it. Some examples of invitation to treat is things like advertisements are typically an invitation to treat because they lack the important information that would make it an offer. An offer is made as soon as the customer approaches the seller with an offer to buy. Defining advertisements as invitations also makes sellers refuse to sell products at mistakenly marked prices. An advertisement is an invitation to treat because the supplier is making representation rather than selling. That becomes an offer then. Typically, if you think about it, auctions can also be invitations to treat, where the auctioneer, for example, puts up an item for sale. They're not making an offer to sell to the highest bidder, but rather inviting others, offers from different bidders. A case in regards to this would be the Pharmaceutical Society of Great Britain against Boots, 1953, which was an invitation to treat, I'll just go through the case with you. So Boots introduced the new self-service system into their shops, whereby customers would pick up goods from the shelf and put them in their basket and then take them to the cash till to pay. The Pharmaceutical Society of Great Britain brought an action to determine the legality of the system with regard to the sale of pharmaceutical products, which were required by law to be sold in the presence of a pharmacist. The court thus needed to determine where the contract came into existence. The court held that goods on the shelf constitute an invitation to treat, not an offer. A customer takes the goods to the till and makes an offer to purchase. The shop assistant then chooses whether to accept the offer, and the contract is therefore concluded at the till in the presence of a pharmacist. Another really important case in regards to invitation to treat is the case of Fisher and Bell, 1961, where the defendant had a flick knife displayed in his shop window with the price tag on it. Statute made it a criminal offence to offer such flick knives for sale. His conviction was quashed as goods on sale on display in shops are not offers in technical sense, but an invitation to treat, and the court applied the literal rule of statutory interpretation. So if we're looking at a difference between the offer and an invitation to treat, an invitation to treat is when a client invites contractors to make him or her an offer. For example, when the client advertises a job on the internet or newspaper, it's necessarily an invitation to treat rather than an offer. Like we mentioned, the auctioneer advertises something that wants to solely attracting bidders, and that's an invitation to treat. The offer only becomes in existence after the client reviews the tenders handed in by the contractors and accepts the offer. An offer, on the other hand, is when the client offers the job to one contractor without advertising the job or having contractors to submit the tender. Making an invitation to treat rather than an offer protects the client from finding him or herself agreed to a contract he or she cannot fulfill. Instead, the client can refuse the contractor's offer for many different reasons. This can be very important protection for the client making the offer if the advertisement for the job offers at a long distance, for example, through the internet or newspaper. Always ensure that any website advertisement make it clear that it's only an invitation to treat. And this was established, as we mentioned earlier, in the famous case of Carlisle and the Carbolic Smoke Ball Company, 1893. I'm going to go on to 2.2, which is now to explain the issues regarding the postal rule. So the postal rules. Postal rules are exceptions of offer and acceptance rules, defining some special problems in distant communication. Postal rules were created as an exception to the general offer and acceptance rules. In general offer and acceptance rules, an offer could be withdrawn or revoked at any time before its acceptance. There are conflicts about when the offer was accepted or revoked. Postal rules were created to solve the problematic issues between offerer and offeree. Distant communication also raised some particular issues. Post or mailing is often referred to as snail mail because it could take a long period of time to get to the recipient. This may cause some problems according to the formation and revocation of a contract. Offerers could not precisely know this acceptance and revocation took place, and that's in the Book of Collins, 2003. In the face-to-face situation, businesses, parties can communicate if any questions occur, while in the environment of distant contracting or indirect businesses, instantaneous method of communication is not available. In this kind of situation, business parties could hardly aware of the acceptance or refusal of a contract. Postal rule is often used to solve problematic cases such as the delay of communication. These postal rules are relevant to the modern day because you can still end up making contracts via letters and by post. Furthermore, there's a general rule that acceptance occurs at the point of communication, as we mentioned, so therefore instantaneous communication, such as a phone call or telex, will mean the acceptance of that's been communicated through the other party. An example of this is, for example, imagine that you are in a Zoom call with an unreliable internet connection. If you tell the other party that you accept the offer, but the internet drops out, you will only have a valid contract when the communication actually reaches the party. Issues related to postal rule. A traditional analysis of contract law prescribes that to be enforceable, a contract must consist of certain identifiable elements, an offer, an acceptance, and an intention to create legal relations and consideration. The problem is that until an offer of acceptance is actually received or deemed to be received, it can be retracted. So because they cannot rely on any legal rule of deemed receipt, a sender, when liaising by email or contractual or time-critical matters, needs to check the email was received, whether by requesting an acknowledgement or by calling to check. Since there are many delays and failures, situation in sending, receiving messages through emails, parties could not get instantaneous communication between the, as we mentioned, the Zoom example. Postal rules should be applied to email contracts, but there are no legislative acts to decide the time and status of that. A really important case in regards to postal communication or postal rules is the case of Adams and Linsell, 1818. In this case, the defendant wrote to the claimant offering to sell them some wool and asking for a reply in the course of post. The letter was delayed in the post. On receiving the letter, the claimant posted a letter of acceptance the same day. However, due to the delay in the defendant's had assumed the claimant was not interested in the wool and sold it on to a third party. The claimant sued for breach of contract, and it was held that there was a valid contract which came into existence the moment the letter of acceptance was placed in the post box. This case established the postal rule, and this applies where the post is agreed form of communication between the parties and the letter of acceptance is correctly addressed and carries the right stamp postage stamp. The exception then becomes effective when the letter is posted. Another case in regards to the postal rule is the case of Holwell Securities and Hughes, 1974. In this case, Dr. Hughes granted Holwell Securities an option to purchase his house for £45,000. The option was to be exercisable by notice in writing within 6 months. 5 days before the expiry, Holwell posted a letter exercising this option. The letter was received by Hughes. Holwell sought to enforce the option relying on the postal rule, stating that acceptance took place before the expiry of the option. And it was held in this case by requiring notice in writing. Dr. Hughes had specified that he had actually received the communication and had therefore excluded the postal rule. Now we're going to look at 2.3, which is to explain consideration in the rules of consideration and the test of enforceability. So consideration, the basic rule of consideration is a promise will not be enforceable unless it is supported by consideration, and the main exception to this rule is promises made under seal. So a common definition is in the terms of the price of a promisee, i.e. for what one party must pay, not necessarily in financial terms, for promise of another party, such that promise becomes legally binding, i.e. gives rise to a valid contract. In other words, for promise, which is an offer, to be legally binding, it must seek something or some action in return. Promisee must show that they have bought the promise either by doing some act in return for it, or by promising to do or refrain from doing some act in return for it. Type of bargain principle, quid pro quo is at work here. So consideration is traditionally needed not just for a new contract to be formed, but also for making effective an agreement to vary or discharge an existing contract. Consideration need not benefit promisor. It can consist simply of some detriment to the promisee or some benefit to a third party. Consideration is to be distinguished from motive or reason for contracting. The consideration is an essential element of the creation of a valid contract. As we mentioned, the consideration must be in some value that can be objectively determined. Consideration is often defined as a benefit or detriment. A person will be found to have provided consideration if they can show that he has conferred a benefit on the other party in return for the party's promise, as we mentioned. In regards to this, we looked at the case of Curry and Misa, which offered a definition of consideration, which was that some right, interest, profit, or benefit occurring to one party, or some forbearance, detriment, loss, or responsibility given, suffered, or undertaken by the other party. And that was the definition in the case of Curry and Misa, 1875. In common law, a promise is not, as a general rule, binding contract unless it's supported by consideration. Consideration, requirements for consideration to be valid. So consideration must not be in the past. Consideration must be given in return for, must be to some extent caused by promise or act or other party. For example, there must be fairly direct correlation between consideration and promise act. Something only done for reason other than promise will not be valid consideration for promise. The requirement is often summed up by the expression, so consideration must not be past. For example, the case of Roscola and Thomas, 1842, and Eastwood and Kenyon, and R and Clark, 1927. In the Roscola and Thomas case, 1842, Roscola purchased a horse from Thomas. Thomas then promised the horse was sound. The horse, in fact, not sound, and Roscola sued for breach of contract. The court said that he had no case. The only consideration he had given was past by the time the promise was made. And the contract was merely that Thomas would deliver the horse on request. Another requirement for consideration to be valid is consideration must move from the promisee claimant, under traditional view, consideration must be provided by promisee in order for them to be able to enforce promise. Thus, party who was not provided consideration for promise cannot enforce promise. It is only the party who was paid for the promise who can enforce it. This is the basis of the rule of privity of a contract. For example, contract between A and B for benefit of T cannot be enforced by T if T not provide consideration for the promise concerned. Another example is if A promises B to pay £10,000 to B if C will paint A's house and C does not so. B cannot enforce A's promise unless B had procured or undertaken to procure C to do the work. However, whether the conditions of the Contract Act 1999 are met, a third party may be able to enforce rights created in his favour by a contract which he was not a party to, and the courts also adopting a more flexible position under the common law here. While consideration must move from the promisee, it need not move to the promisor. First, consideration may be satisfied where the promisee suffers some detriment at the promisor's request but confers no corresponding benefit. For example, the promise to give up tenancy of a flat may be at adequate consideration even though no direct benefit results to the promisor. And secondly, consideration may move from the promisee without moving to the promisor, where the promisee at the promisor's request confers a benefit on a third party. In situations where goods are bought from a credit card, the issuer makes a promise to the supplier that he or she will be paid, and the supplier provides consideration for this by providing goods to the customer. The case in regards to that is the case of Tweedle and Atkinson, 1861. In this case, the son and the daughter of the parties involved in the dispute were getting married. As such, the father of the groom and the father of the bride entered into an agreement that they would both pay sums of money to the couple. Unfortunately, the father of the bride died before he paid the money to the couple, and the father of the son died before he could sue on the agreement between the parties. So as a result of this, the groom brought a claim against the executor of the will for the payment that there was previously agreed between the fathers. And the groom's claim was rejected by the court. It was held that the groom was not part of the agreement between the fathers, and he did not provide any consideration for the promise made by the father of the bride. Also, as a stranger to the contract, the son could not enforce it. On the basis of this, the court actually found in favour of the executor of the will. Another requirement is that consideration must be legal. Under traditional view, consideration must be provided by the promise in order for them to be able to enforce the promise. Consideration cannot be something or some act which is illegal, immoral, or contrary to public morals. And the case example was the case of Wyatt against Craglanger and Furno, 1933. In this case, Mr. Wyatt was a manager employed by Craglanger and Furno, KF. On his retirement, they wrote to him granting him a pension of £200 per annum, providing that he did not enter the wool trade or act in any way to his employer's detriment. The pension was paid for approximately 9 years, but then KF wrote to Mr. Wyatt advising him that the pension was to be discontinued. Mr. Wyatt saw a declaration that KF were liable to continue to make the pension payments. The court held in this case that Mr. Wyatt was unsuccessful in his claim, even if the letters amounted to an agreement on the terms contained within them. Such agreement would be void as being against public policy, and in restraint of trade, it would be against public policy to seek to restrict competition in this way, and any such agreement was therefore unenforceable. The next one is consideration must be requested. So there must be express or implied requests by promisor to promisee for consideration. It should be distinguished from the conditional gifts. Then the next one is another requirement is consideration must be sufficient. So consideration must be sufficient to provide some benefit to the promisor or some detriment to the promisee, but benefit or detriment need not amount to much. And the case was, the case example is Thomas 1842, where an agreement was made that a woman was allowed to reside in a property for £1 a year, and this was sufficient consideration. It was not mere gift. And then the other case is Chappell and Nessel, 1960. In this case, the defendants Nessel contracted with a company manufacturing gramophone records to buy several recordings of music. The plaintiffs, Chappell and Co., held that the copyright in these recordings. Nessel offered to sell these recordings at a discount price to anyone presenting 3 wrappers from their chocolate bars. The wrappers themselves were worthless and were thrown away by Nessel. The plaintiffs sought an injunction restraining the manufacture and sale of the records because they breached copyright. The House of Lords held that the wrappers did not form part of the consideration of the records, despite in that fact they had no intrinsic economic value in themselves. Therefore, as the wrappers had no monetary value, the sale was not covered by Section 8 of the 1956 Act. And the Lords found in favour of the defendants. So it was the Copyright Act 1956. Then, nevertheless, consideration must have some economic or material value, even if negligible. Consideration cannot consist solely in leading in sentimental or otherwise emotional value. And the case in regards to that was the case of White and Blewett in 1853, US case of Hammer and Sideway, 1861. In some cases, consideration can be provided by promise not to sue, and the case in regards to that is the case of Alliance Bank Limited and Broome, 1864. Now, in this case, the defendant owed an unsecured debt to the plaintiffs. When the plaintiffs were asked for some security, the defendant promised to provide some goods but never produced them. When the plaintiffs tried to enforce the agreement for the security, the defendant argued that the plaintiffs had not provided any consideration. It was held that normally in such a case, the bank would promise not to enforce the debt, but this was not done here. By not suing, however, the bank had shown forbearance, and this was a valid consideration, so the agreement to provide security was a binding one. Requirements for consideration. Consideration must be sufficient. Forbearing to enforce a legal claim will only amount to a valid consideration if the claim is reasonable as opposed to frivolous or vexatious. B, promisee honestly believes claim would be successful. C, promisor has not concealed facts from the promisor which would affect validity of a claim. And D, that the promisee envisages intention to bring proceedings if the promise not honoured. Again, parties promise not to enforce existing claim will only provide consideration if the promise provided in return was actually induced by the promise not to enforce it. And this was the leading case of Combe and Combe in this 1951. In this case, during the divorce process, a husband promised to pay his wife a tax-free sum of £100 each year to represent a permanent maintenance payment. The wife was aware that the husband was not in a good financial state and made no claim to this payment. Several years later, she brought an action to claim the arrears that were owed under this agreement. The court held that the wife could only enforce her agreement for the payment which was promised by the husband if she had given consideration. The court found that there was no consideration was given by the wife as she had not agreed to apply for the maintenance that was promised by her husband. The husband did not request the wife to refrain from taking the maintenance payment, and therefore the wife could not claim for the money. So the next requirement is performance of existing duty. Performance or promise of performance of an existing duty will usually not amount to consideration. The rationale that the promisee suffers no legal detriment, they can already be sued to enforce original promise, and promiser only obtains that to which they were already entitled, but courts have increasingly introduced exceptions to this rule. And there are three main types of existing duty. Firstly, public duty, which is person carrying out duties which they are required to do under general law, will not provide consideration unless they do something extra. And the main rationale is to discourage persons with public duties for demanding additional contractual payments of or other benefits for carrying out these duties. And the case in regards to public duties was the case of Glassbrook brothers against Glasmorgan County Council, 1925. In this case, Glassbrook and Glasmorgan, during a miners' strike, and mine owners were fearful of violence occurring. Their assessment of the amount of police protection that they needed differed from that of the police whose job it was to provide it. Eventually, the police did agree to mount a stationary guard, which they did not necessarily, but they did so on the basis that it would be paid by the company. The company agreed to pay for more extensive police operations, but later refused to make the payments, claiming that the police were entitled to recover as they had done more than they perform existing duty. Performance of existing duty. Existing contractual duty to the promisor, traditionally found not to be consideration, for example, in the case of Stilk, Myrick 1809, or Hartley and Ponsonby 1857. The basic concern of courts here was to minimize the risk of extortion and duress. If one party's promised to perform an existing contractual duty to supply goods or others confers an extra particular practical benefit on the other party, it will be sufficient consideration to make a promise given in return binding, as long as there's no duress to involved and the parties are involved in genuine renegotiations of the contract. So requirements for consideration, another one is the performance of existing duty. In this A, promises C that A will perform contractual obligation already owed to B. The performance of that obligation can equal good consideration from promise made to by C to A. And the leading case is the case of Shadwell and Shadwell, 1860. In this case, the defendant was the plaintiff's uncle. The uncle promised to pay his nephew £150 a year until the nephew's income reached 600 guineas, provided that the nephew married his fiancée. The uncle paid 12 installments, but then died, and the payments stopped. The nephew sued his uncle's estate for the remaining payments. The Lord Justice Earl said that the performance of the managed contract was consideration, even though the contract was made with the third party to the agreement, as the uncle's promise was an inducement to the nephew to perform his contract. He said that the plaintiff had, by getting married, made a material change in his position and had induced his wife to do the same. They may have incurred pecuniary liabilities that would be a loss to them if the promised income was withheld. He recognized that marriage could be a benefit to the interested parties, and so the uncle didn't derive a benefit from the consideration. Therefore, the marriage was a good consideration in this instance. Another case in regards to that is the New Zealand Shipping Company against A.M. Satterthwaite and Co. 1975. So we've finished in regards to learning outcome 2 now. The next learning outcome is learning outcome 3, which we'll be discussing tomorrow. The references we've used in regards to learning outcome 2 is some resources in regards to books on Anson Law of Contract. There's a list of all the ones that we've used for today's learning outcome 2, so you could refer to them. A lot of the sources are available on Moodle for you, so please refer to Moodle for any sort of resources that you need to help you with learning outcome 2. and also for any additional reading, refer to Moodle. And also the next session is Learning Outcome 3. So thank you for attending today's session, and I will see you in the next session. Thank you.